Carol was saying, we're talking about qualification for unemployment. And this again is the separate track of the parallel universe that you're in. In one universe, again, we're talking about eligibility, monetary eligibility, and are you able to work, available for work, actively seeking work, doing weekly claims. That's one universe. The other universe is, are you qualified for unemployment compensation? And there's 3 reasons you can be disqualified. Next, you quit your last job without a good cause, or you were discharged for work-related misconduct, or you don't apply for or accept suitable work. And if you are disqualified, and that is a final determination, not appeal, within that 30 days, you can't get unemployment compensation until you get another job and work at that for at least 30 days or 240 hours, and that has to be for one employer, and you lose that new job through no fault of your own. That's the only way you will ever get rid of that disqualification. So not being disqualified is really important. Next, let's talk about voluntarily quit without good cause. If you voluntarily leave and you do so without a good reason or a good cause, you can't get unemployment compensation. And the burden is on you to show that you had a good reason for quitting. It could be that the job was dangerous to your health or safety, you weren't being paid at least minimum wage, or you were being cheated on your wages, or any of a host of really good, compelling reasons. But that's only half of the battle, and that's not even the most difficult half of the battle. And this is kind of a good example of how judges actually make laws. Because if you look at the Unemployment Compensation Code, it just says that you will be disqualified if you leave without good cause. But when you look at the decisions that the courts write interpreting that code section, you have to take voluntarily leaving employment requires that an employee take all reasonable steps to resolve his conflict with his employer and retain his employment before voluntarily leaving that employment. That's not in Code of Virginia. That's in court judge decisions interpreting the Court of Virginia. And that is as important, if not more important, than just leaving for good cause. Because your employer is not a mind reader. Your employer has to know what the problem is and be given a reasonable opportunity to fix it. So if there's a grievance procedure, you got to use it. If your supervisor, if you got a problem, bring it to your supervisor. If your supervisor is not responsive, bring it to your supervisor's supervisor. If there's some independent government agency that might be able to help, whether it's a wage claim, whether it's a health or safety problem or something of that nature, report. And as Carolyn said, keep documents, keep journal, keep copies of letters or emails or print out when you send it on the internet. Have all of that to show that you made all reasonable efforts to keep your job before you decided to voluntarily leave. Next slide. Now, you would think that being asked to leave your job wouldn't cause you a problem. But a lot of people run into problems like that when their employer says, well, why don't you voluntarily resign? It'll be easier for you to get unemployment compensation that way. It'll look better on your record. Well, it may or may not look better on your record. It definitely will not make it easier for you to get unemployment compensation. And if you're asked to resign from your job, don't do it. It's as simple as that, because it really makes things a little more difficult. Now, if you're asked to resign from a job, and instead of being fired, you're given that choice, quote unquote choice. But in fact, it's clear that it is no choice at all. That unless you sign that statement, when you write out that statement on your own and sign it voluntarily leaving, if you don't do that, you will be fired. That's a forced resignation, and there's ample law out there that the Virginia Employment Commission has that says that is not a voluntary quit. That is a discharge. The easiest way to deal with the situation is to avoid that in the first place and never voluntarily resign or sign a resignation letter, because that is truly your free choice. That's nothing that is forced upon you at all. Next slide. which gets into the very next issue of, did you quit your job or were you discharged from your job? And the law here, again, places the burden on your former employer to show that if it was a quote voluntary quit, the burden is on the employer to show that it really was voluntary. And voluntary means, and this is quote almost straight from the court decision that interprets what a voluntary quit is. It means not constrained by interference, not upheld by another's influence, spontaneous acting of oneself, resulting from free choice. Now, you don't necessarily have to say, I'm resigning, or I'm quitting, or I'm leaving, for that to be considered a voluntary quit. You look at the total conduct, both words and conduct of the employee to determine, did they really voluntarily resign, or were they, in fact, discharged? So it's really important to know what efforts you made to keep your job. Did you continually contact the employer, let them know that you were willing to work? I mean, I had a lady in my office just literally yesterday get into a dispute between she and the former employer, and she says, I was called into the office, I was told I was demoted, I was told to leave, I was told that they'll contact me when they need me back, and so that's what she did. And they never contacted her back. She applied for an employment compensation. Virginia Employment Commission turned her down, said she voluntarily quit, and based even on the employer's statement that allegedly she called and said, I've been advised by my attorney not to come back until further notice, and the VEC treated that as a voluntary quit. Well, factually, she didn't call the employer and say that at all. And again, the burden would be on the employer to prove that she, in fact, said she wasn't going to come back. So, again, you look at what the employee said, what the employee did to determine whether they voluntarily left or they really were discharged. Next. Now, if it's clearly a discharge, then that's not going to disqualify you from unemployment compensation unless it was for deliberate, intentional, willful, purposeful, work-related misconduct. Next. And the definition of misconduct has remained pretty much unchanged for over 30 years. And just quoting directly from the major court case that defines it, misconduct is when you deliberately violate a company rule reasonably designed to protect the legitimate business interest of his employer, or when his acts or omissions are of such a nature or so recurrent as to manifest a willful disregard of those interests, duties, and obligations he owes his employer. So basically, as the slide points out, the employer has to prove that you knew something was wrong, and you did something wrong, you knew it was wrong, and you went ahead and did it anyway. And virtually every unemployment compensation hearing I ever do, the appeal examiner will ask my client, did you know your job was at risk? And if the answer to that is no, then it's tough for the former employer to prove work-related misconduct, that you intentionally, deliberately, willfully did something wrong. A couple of examples. I had a client who violated the no cell phone policy at, I believe it was a major cigarette maker that starts with P and it ends with M, in Richmond. And he honestly didn't know that he had the cell phone in his pocket. I mean, it's basically his daughter had given it to him to put some minutes on the phone. He stuck it in his pocket, forgot about it. Forgetting is not deliberate, intentional, willful misconduct. Making a mistake is not deliberate, intentional, willful misconduct. And even if you violate a rule, that rule has to be an important rule. It has to be a rule that protects the legitimate business interest of the employer. I see we've got these cell phone cases. I got another cell phone case where a lady who was working at a convenience store that rhymes with Heaven 11, and they have a policy there that if you buy something there
You can put it on your what they call the grocery